Hello everyone, welcome to Learn Law with AKP. In today's class, we will study conditions and warranties under the Sale of Goods Act 1930. This is one of the most important frequently asked topics in the entire Sale of Goods Act. Questions on conditions and warranties regularly appear in LLB semester exams, AP Law Set, TS Law Set, and judiciary examinations. Therefore, every law student must clearly understand the meaning, differences, legal effects, and remedies available in case of breach. Let us begin. In every contract of sale, the parties include certain promises and terms. These terms are called stipulations. Some stipulations are so important that they go to the root of the contract. Others are secondary and support the main purpose of the contract. The law classifies these stipulations into conditions and warranties. A condition is a stipulation essential to the main purpose of the contract. It goes to the very root of the agreement. If a condition is not fulfilled, the buyer may reject the goods and terminate the contract. For example, a person purchases a car specifically. A person purchases a car specifically described as a brand new 2025 model. If the seller supplies an old used car, the condition is breached because the main purpose of the contract is defeated. Now, meaning of warranty. A warranty is a stipulation collateral to the main purpose of the contract. It is less important than a condition. Its breach does not allow rejection of goods. The buyer can only claim damages. For example, a new car is delivered exactly as ordered, but the stereo system promised by the seller is missing. The buyer generally cannot reject the entire car but may claim compensation. Now, the difference is extremely important for examinations. A condition affects the very foundation of the contract. A warranty affects only a secondary aspect. Breach of condition permits rejection of goods. Breach of warranty permits only compensation. Students should always remember this distinction. Now, when a condition is breached, the buyer receives strong legal remedies. The buyer may reject the goods, treat the contract as terminated, claim damages suffered due to the breach. This is because the fundamental purpose of the agreement has failed. In breach of warranty, the buyer has limited remedies. The buyer must generally accept the goods. However, the buyer may claim compensation for the loss caused by the breach. This reflects the less important nature of the warranty. Now, when conditions become warranty. Section 13 provides an important exception. Sometimes the buyer voluntarily chooses to treat a breach of condition as a breach of warranty. In such a case, the buyer keeps the goods and claims damages instead of rejecting them. For example, a machine supplied differs slightly from specifications. The buyer still wishes to use it and therefore claims compensation rather than cancelling the contract. Now, conditions and warranties may be expressly stated by the parties. They may be written in the contract or agreed orally. These are known as express conditions and warranties. Their existence depends on the agreement between the buyer and the seller. Now, the law itself may impose certain conditions and warranties even if the parties do not expressly mention them. These are called implied conditions and implied warranties. Their purpose is to protect buyers and ensure fairness in commercial transactions. We will study these in detail in the next topic. In the famous case of Poussard versus Spiers, an actress failed to perform at the beginning of an opera season due to illness. Her appearance at the opening performances was considered a fundamental term of the contract. The court held that this was a condition because the condition was breached. The other party was entitled to terminate the agreement. Here, the principle established breach of a condition permits termination because it affects the root of the contract. Now, consider a practical example. If you purchase a laptop specifically because it contains a latest generation i7 processor, this specification is a condition. If the laptop contains a lower processor, the contract's main purpose fail. Now, suppose the seller promised a free laptop bag. If the bag is not supplied, the laptop remains useful. This becomes a warranty. The buyer may claim compensation but generally cannot reject the laptop. Let us quickly revise. A condition is essential to the contract. Its breach permits rejection of goods. A warranty is collateral to the contract. Its breach permits only damages. Remember this distinction carefully. Now, let us conclude today's topic. Conditions and warranties are important, important contractual stipulations under the Sale of Goods Act. Conditions are essential terms that go to the root of the contract. Warranties are secondary terms collateral to the main purpose. The remedies available depend upon whether a condition or warranty has been breached. Therefore, understanding conditions and warranties is essential for every law student studying the Sale of Goods Act. For examinations, always remember definitions, differences, remedies, illustrations, and case law. Thank you for watching. If you found this video helpful, please like, share, and subscribe to Learn Law with AKP. Stay tuned for the next topic.